playback. We have a channel that these come out on. You are also welcome to go to our website where there are many of these programs that are still active as far as the CLE numbers, and then some that aren't, but they're very interesting, and encourage you to check out our offerings. So I welcome you to Upchurch Watson White Max Mediation Group's webinar, and this we do in conjunction with the University of Florida Levin College of Law and their Institute for Dispute Resolution, which we've been proud to co-sponsor these with over the years. This is really the first time we're using the Zoom platform, though we use it every day for mediation. In this webinar, we're trying a little different, being on camera and whatnot. So we hope that you enjoy it. Jeff and I are now at 10 years here, so we thought this is a good time to kind of check in with everybody and talk about the things that we've experienced in the decade here with Upchurch. So I know you have a little bio in our registration form, but just to give you some background, I was a litigator for 20 years doing different types of trial law and insurance on IP, and then I served in the general magistrate in Ninth Circuit here and became a member of Upchurch in 2014 with the group in Maitland. Now we're in downtown Orlando, and that's where Jeff and I are coming to you from today. And we wanted to show you a little bit. This is our large 40-person arbitration conference room that we have split in half. He's just on the other side of that wall. I have been mediating since 2001, arbitrating since 2005. And we really have been doing this mostly online, but we have this beautiful office here in downtown Orlando, as well as any Veritext office that you want to do something in. We're likely to be able to do that. So if you want to, we're going to talk a little bit about differences of in-person and online mediations. But if you want to come back, we're here, and we have brand spanking new offices for you. You can find things I write about at orlandomediator.blogspot.com. I've been doing that since about 2010, and I try to keep everybody up on the latest with what's going on and trends out there and things like rules changes and other geeky things on mediation and arbitration. So Jeff, tell us about yourself.
All right. Well, good morning, Lawrence, and everyone in attendance. I should say good noonday here. Yeah, I'll keep this brief about how wonderful I am. You know, for the past 10 years, I have had the privilege to work with great mediators like Lawrence and others at Upchurch Watson White Max. I happen to be from Orlando, looking out a window here, back to where I started practicing. Joined a civil litigation firm right out of law school, trial firm, tried some cases, became a board certified civil trial lawyer, partnership, all that. Stayed with them for 16, 17 years. Very much enjoyed that, but wanted to be a judge. Fortunate enough to be appointed first as a county judge, Orange County, and then appointed to the circuit bench, Orange Osceola. Served on the court for a little over a decade, 11 years, served in all the different divisions, actually made it back to circuit civil towards the end of my judicial career. Left the bench voluntarily in good standing, went back into practice, lawyering again for a short period of time, and realized I really wanted to get back to a neutral capacity. So I joined the Upchurch group in 2014, which was kind of the impetus for this webinar. And so my career is a little unusual in having been a trial lawyer for over a decade, trial judge, and now a mediator for over a decade. I'm a certified circuit, appellate, family law, and federal court mediator, Florida Supreme Court qualified arbitrator, and a special magistrate. So I do occasionally help out the local judiciary with sub-issues that they assigned to me. And as Lawrence mentioned, we are broadcasting, if I can use that term in a webinar, from our beautiful Veritext office. I think we have some photographs of the office. Yep, there we go. Look at that. Downtown Orlando, actually north of downtown in the Wells Fargo building. And I am told that I'm the first person to actually use this room. And as you said, Lawrence, you're a divider across the way from me. So I guess we're the first people to officially use these offices. So I think we got maybe a couple more pictures there, and then there we go.
I'm looking right at the courthouse, so it's
yeah,
really...
I know. I'm looking back at I was on the 17th floor up there, so I think I could
your chambers from here.
Just about see where I used to work up there. So, and then maybe we have one more photograph here. Yeah, there we go. I think that may be
Yeah,
the,
that's where we are, and
it's
we're kind
actually
of
the
saying that the
room that we
body.
are in.
Yeah, so we can
So,
accommodate, your multi-party construction, your large arbitration, whatever you might have. And then there's a nice place to eat in the building and several places within walking distance, and it's easy in and out parking. So that's our plug for coming back in person.
yeah.
So Jeff, we have some questions we're going to ask each
I think
other.
there's one a title page there. Yeah. And let me just make a quick comment about, again, the sort of the impetus for the webinar. You see the title, Lessons from a Decade in a Dedicated Mediation Group, What We Have Learned Along the Way. My emphasis here is very practical. What I'm going to share with you is what I've learned from doing this for over 10 years. But I want to emphasize that, one thing I've learned is that there are a lot of different ways to be successful as a mediator. So take from this what you will, but I can just promise you that this is all from my own practical experience.
So I guess I'll start with, how do you see this process of mediation differently, having been a judge, a trial lawyer, now that you are a mediator for a decade?
Well, as I said, I think the first thing I learned is that, there are a lot of different ways to do this. But what I will emphasize is what's worked for me. When I first started mediating, I relied heavily on my experience as a trial lawyer and, of course, as a trial judge. And that served me well. But as a trial lawyer, my approach was very much that of an advocate. And as a judge, you don't really have much connection with mediation other than ordering it. Although as a judge, it certainly gave me an appreciation for how the court system works, how judges make decisions, and exposed me to a lot of different areas of law. But maybe most importantly, preparing for what would eventually be my work as a mediator and other neutral capacities is, having to approach everything from a position of neutrality. So while I drew heavily initially on my experience as a lawyer and a judge, litigator and a judge, at some point I realized that really what was helping me get cases settled wasn't so much that background, but it was really more my experience as a mediator. And I think the big takeaway, I never appreciated this, and I don't know how you can really, without serving as a mediator, is what a position of trust that it is. And, that position of trust um, allows us to take deep dives into people's lives and see people at their most vulnerable and honest and raw in a lot of cases. And, to go from one room to the next and experience that exact same thing from different rooms who are saying exactly the opposite things is really kind of eye-opening. That people can feel so strongly and be so sure they're right about something when the other side is feeling the same way. And I think that just emphasizes that, um, this is not about trying to convince the other side that they're wrong. That rarely happens. But what you can do, I think, if you can get people to talk long enough and think rationally enough about things, is get a glimpse into neutrality, into objectivity, and think that they might be wrong. And it's that might be wrong, that it might not go your way, which is really the foothold that mediators need. So I would say, Lawrence, that really is how I see the process differently, is that I really understand now that people don't secretly think that your side is right. They really believe in their own version of events, and your job is just to help them get a glimpse of the other side and work with that. So that would be my big takeaway.
Makes sense.
And Lawrence, do you still mediate and arbitrate cases in person?
So, we were just talking about this in terms of having new digs here. Certainly a lot less in person, right? There's some old school, dyed in the wool types that that they only believe that can take place in person. But I really think it depends on the gravity of the case, the subject matter, emotional components. You have a death of a child, for instance. I had an unusual defamation case where, because these people were online defaming each other, never really sat in the same room, we were able to bury the hatchet because we were in person. There's things where you want to present evidence or you want to bring an expert and have a little bit of a presentation beyond share screen. So we think, there are cases that warrant that. And there's people that still want to bring notebooks and things like that, and that's fine. Whatever makes you comfortable, we'll do it either way. So yes, we do, but I think the majority of this has shifted, and we've moved where the audience is and where your desires are, and that's been Zoom. So Jeff will comment a little bit about the difference between the two, but I think we've largely overcome that. We've certainly had surveys of up to 1,000 mediators, which said their success rates were essentially the same once everybody got used to doing this. And we find that the parties are so used to Zooming with family and for work and this and that, that they're very comfortable in it as well. And sometimes you have a glitch or two, but I really haven't experienced that. And the fact that you can, attend on an iPad, for instance, and even sign the agreement. We use Adobe Sign, and to send that around, have somebody scribble with their finger at the conclusion just makes everything that much easier. So, do I miss being in the conference room at midnight, writing up something by hand and getting the signature, the wet ink? It's just what we used to do, and this is where we've gone. So. Yes, we do it, and we're here for you, and we miss people. We're often lonely in our little laptops wherever we're doing this, and I've done this also from other offices and from my home. And I was telling Jeff I was even in the Times Square office of Veritex, which is a beautiful building overlooking all the hubbub. And I was asking the reception there, how often do you see people in person? And it's not often in New York either. So I don't think we're alone in this, and the culture has just shifted. And but we do recognize that when those cases are significant and you want to be here, we're here for you. So Jeff, I think I'm going to ask about really the comparison in your mind about the remote and in person and your experience.
Well, I think at the risk of stating the obvious, I don't think there's any substitute for in-person, face-to-face communication. There's just subtle nonverbal cues that you're going to pick up on when you're in the same room with somebody, that even as wonderful as Zoom is. And I say Zoom, I know there are other remote platforms, but we pretty much everything we use is Zoom. And so I don't think they're the same. And one thing you lose when you're doing things remotely is the chance meeting. You run into somebody in the hallway, and there's a certain spontaneity that I think is lost when we're doing things remotely. But having said that, I am very thankful for Zoom. Zoom or remote platforms allowed us to keep going, obviously during COVID when we couldn't get back together, and really has revolutionized how we do things. So I am very thankful for it. It has a lot of useful options where we can move people around. And in fact, I had a mediation yesterday where I pulled the lawyers out and just the attorneys were talking. So that's something you can obviously do in person, but with Zoom, you can actually do that sort of thing more conveniently. But let me be really candid about this. I mean, I sort of have a love-hate relationship with Zoom in this, and it's not Zoom, but it's the fact that we still, even though we're 4 or 5 years in on this, as you know, we still have people who appear, maybe through no fault of their own, they don't have adequate Wi-Fi, they don't have adequate equipment, they don't often don't appear by video, and I think that impedes the process. And when people are appearing remotely, sometimes that's by choice. They're not appearing by video, and they're doing other things. So that that's a distraction. I have become increasingly direct about not wanting that. I'm not somebody who say, I'm not going to do a mediation if someone doesn't appear by video, although I'm kind of tempted, but I do at least ask people if they have a video, and I will encourage them to appear by video. And certainly people sometimes appear by videos, and they're driving, they're doing all sorts of other things. And we don't want people doing anything that's not only distracting, but potentially dangerous. But let me be practical about this. Um, I would encourage you, counsel, to make sure that your clients are able to appear that they have adequate technology. And if there's any question about that, you can always invite them to your office. So I think that works well. Even though we're still using Zoom or we're appearing remotely, we have everybody who's in one location that has adequate technology. We can also do hybrids. It doesn't have to be all one or the other. I had a mediation where actually a lawyer doesn't like remote, came to my office, but I was out of town, so I appeared by Zoom. The other side appeared by Zoom, but they were in my office. So there's sort of this hybrid flexibility. The other thing I would suggest to make Zoom or remote appearances go smoother, people appear on Zoom and they don't even know, maybe, are aware what name they're appearing under. It's not their name. It's the cat's name or something. They don't necessarily have to correct that, but you might point that out because it's confusing to other people, certainly to the mediator, and ask counsel to introduce everybody so we know who's appearing. So I think that's helpful. Also get cell numbers in case you do have connection problems. I find that sometimes we just have to go by using the phone, and if you get those cell numbers ahead of time, it definitely makes that easier. So those are kind of my observations, Lawrence, comparing the two. How do you think mediation has changed since COVID and the advent of Zoom?
I think, way less cancellations for sure. There's just not as many problems getting a flight or, having someone last minute not be able to attend in person. And so I don't see as many that we, had experienced when everybody was coming from somewhere else. I think in general, we get to the finish line quicker. People, when they, get into a rhythm of negotiation, when they finally looks like the case is going somewhere, there's going to be an agreement. It seems to end a little faster because, the platform, you don't want to be prisoner to your desk or chair the whole time. So I do think that ends up being a little bit more efficient. And, I think it's flexible. You can, like you said, have a hybrid, things like that. Sometimes that doesn't work so great, but it's available, and it's, a thing that I think promotes maybe some less moves and more getting down to brass tacks earlier. There's still room on the platform to get those cues and have some rapport built, and especially when you're in breakouts. And I generally do create a kitchen or a hallway room where I can, if I need to, hustle the counsel on the side. So there's definitely the flexibility there. And I think just we're kind of people that came up through in person, and we're just very good at that and used to that. But this hasn't been that difficult to try and use some of those techniques and persuasion through the video. I think it works okay. And as I said, it's because it's not just for mediations, because people are used to doing this in general.
Well, it's certainly very convenient, eliminates a lot of unnecessary driving, and I think it allows things to be scheduled easier, and it also allows key players to appear that might not otherwise appear in person. So I certainly am very aware of that. I also kind of think it makes it maybe easier to cancel things as well because people don't have flights to cancel. But overall, in terms of actually getting things done, there's no question that the remote process has served us very well.
So what do you like to get in advance of a mediation these days?
Well, I'll take what I can get. Something is better than nothing. But what I really want is something that summarizes and identifies, the basic factual contentions, the legal issues, who are the key players. We're talking about Zoom. When you sign on to Zoom, sometimes you have all these people popping up. and who are they? So I really like to know who they are and why they're here. That's one thing I have to say, having been a judge, that I kind of carried over. A lot of times going into hearings, I really would have minimal time to truly read everything that was sent to me. But at least if I know who the players are and what the issues are, I know how to ask the right questions. So that really is what I'm looking for. And if I don't get something, my practice is the afternoon before, I'll send out a kind of an email saying, not requiring it by any means, but please send me something if you want to. But what I really like, to answer the question, is something that actually summarizes the case. And I find that maybe 3 to 5 pages is about right. And what is not necessarily helpful is, although again, I'll take what I can get, not complaining, but sometimes I just get sort of a blow by blow chronology of events, maybe medical history, what have you. I don't know if I'm really expected to read that, and it can be helpful, but it is not as helpful as getting an actual summary. Dispositive motions are good. Motions for summary judgment, certainly orders that have been entered, those are very helpful in summarizing matters. And what I love are PowerPoints. Certain lawyers are very comfortable with PowerPoints. They prepare them and intend to use them in their opening presentations. And I would just encourage you, if you're doing that, go ahead and send that to the mediator. You can do that confidentially if you choose. If they're not too lengthy, will print them out. I do this in arbitrations too. Print them out, have post-it notes ready, taking notes and writing on them. It really is an excellent way to condense a lot of information and allow me to refer to it to later. I don't make a practice of routinely scheduling phone calls in advance, although some mediators do. But if I have any questions, I receive a summary and something I don't understand, I don't hesitate to call the attorney and get clarification. So that's basically my preparation approach. So do you think the parties are prepared in the same manner as they used to be? What do you think?
I think it's dropped off in terms of seeing, like as you mentioned, less summaries. Even in person, you used to have a lot more dog and pony show, even a pre-drafted mediation agreement or release, um, something of a demand package that you could really, sink your teeth into. So and I understand that. I mean, I was a trial lawyer running around from fire to fire. You look at your calendar a few days ahead, you're like, it's coming up, but sometimes you don't have something to put together and you don't have an associate to dump it on, and you give them a summary judgment or whatnot. We go in the dockets, we look, we try to figure out what's going on, and we do pick up the phone, but not everybody's sitting at their extension in their office anymore, so it's very hard to reach people. Sometimes the cell phone, I don't, it's someone I haven't worked with before. I always try to get that anyway, because I want to touch base and get a little bit of a heads up on what's to expect, and especially what to expect from your client, because you can't really sit there and talk about your client in front of them. So I want to know, is this guy a hothead? Is this person, going through some emotional thing that needs to have some catharsis through the process? Do I, where am I focusing my attention? Are you having your own issue with the client about this case? And so those are things I need to know, in advance or separate from, um, the general. And I think that people come and they share a screen and they pull up things, and I mean it works. But no, I think generally we're seeing less. I'm asking other mediators too. We're seeing less and less summaries. We're seeing no certificates of authority. I got to go look for that too, and I'm not going to police those. But I want to know, like Jeff said, who's coming to dinner and have an idea. And if it's going to be a substitution or somebody, then we can talk about that. But I don't generally want to be the guardian of who's actually in the room. You guys figure that out. We're willing to have everybody that needs to be there, and I think we're going to talk about this a little later in the presentation. But those things really do help us get a jump and come into it prepared and try to make a quick work of the characters and what's going on in the case. Jeff, on the introductions. So we have the things that we have to do by our ethical rules that, we're not deciding the case and that the people are there voluntarily, and everything's going to be confidential. But what do you do to sort of jazz up your introductory comments?
Well, first of all, because we are generally on Zoom, the very first question I ask after everyone's been identified who's there is there anybody in any of your respective rooms who we can't see, but who can hear what we're saying? So I don't know if that's routinely asked, but that is very first question, because I have learned to ask that because I throughout the course of a Zoom mediation, I see somebody's shoulder, ear, or something like, oh, there's somebody else in the room. Who is that? And so I would encourage you to ask that question, because it's not unusual that there are people that you're not aware of. And because it is a confidential process, you need to ask that. I also make the point that as the host, I can record the session and that I'm not going to do that. And I also ask that people please don't use any devices to record the mediation. So I don't think those are things we generally would be concerned about in person, but I do think it's worth commenting on in a Zoom context. As you mentioned, I think we're required as mediators, and of course, I do cover confidentiality. My practice is that everything you tell me is confidential unless you say it's not. Now, the rules authorize you mediators to reverse that if everybody's in agreement, but I generally don't do that. I treat everything as confidential. I emphasize that I'm neutral, that I don't have an interest in how the matter is resolved, of course, and that this is a voluntary process, and that self-determination is the cornerstone of mediation, as we say. I do something that I don't know that a lot of mediators do, and I'll comment on this again later if we have time, but I remind, air quotes, kind of remind the attorneys, because I don't know if everybody knows this, that both by statutes, actually section 441011 sub 2, mediation is an informal and a non-adversarial process. And that's also contained in the rules for certified and court-appointed mediators. So I always say this because I say this is a nice way of me saying I don't need to hear an argument about the case. So this is assuming that we're going to do an opening session together. So I emphasize that. I briefly touch on my background, which I did at the beginning of this, so I won't bore you with that again. But I do, I do touch on my litigation experience and briefly my judicial experience, just to kind of emphasize that I've handled a lot of different kind of cases or been exposed to a lot of different areas of the law. And as a result, I mediate a lot of different kind of cases. And what I've learned is kind of a common denominator is that this is an emotional process. Mediation is an emotional process. And that's not just limited to individuals who do it once in a lifetime. It seems equally true of lawyers and insurance representatives and corporate representatives and what have you. I mean, people are emotional creatures. Money's an emotional subject. And I've learned that actually is why mediation works, is that it is a forum where people can say and do what they want within reason. And you don't have to be concerned about that, especially in a confidential context. But I also point out that I can't mediate a lot of that. My view is that although it's not a perfect system, that cases actually are decided on the facts and the law. And I make this part of my opening comment, that while certainly jury trials are unpredictable, and they are, I, as a lawyer, lost some. I think I should have won, and vice versa. But overwhelmingly, my observation, particularly from the bench, was I'm not going to say juries always get it right, but they do try. We don't pick the first 6 people wandering out in front of the courthouse the morning of a trial to sit on a jury. It's jury selection process takes place, which is often the most thorough and maybe important part of trials. I just saw over and over again, the people who make the cut and are on the jury who raise their right hands, they're sworn in to answer questions truthfully, then sworn in a second time to listen to the evidence and follow the law. And I think they do that. It's not a perfect process, but it's just a way of me emphasizing, that in mediation, this is what I care about. What are the factual issues? What are the legal issues? Say and do what you need to do, but let's get back to that. And let me emphasize that. And I kind of emphasize that myself, Lawrence, in my opening comments. And so while I don't play up unpredictability, I don't really think that helps get cases settled. I do play up and emphasize closure. I do agree with sort of the adage that a good mediation is one where both sides leave unhappy, but really my observation is in cases that settle is that, boy, closure sets in pretty quickly, even in cases where people
Relief.
are very unhappy.
Yeah.
And once it's settled and you can just see the relief. It's on our website, this situation I had when I was a young mediator where a lady actually gave me a hug at the end and was just so relieved that the matter was over. And she had said almost nothing. I had no idea how stressed out she was. And the case settled and closure set in. And so that really is inspiring. And it's just something I I don't talk about the hugging incident every mediation,
Oh,
but
I've
I
been
do
there too.
emphasize closure. I
You
do
can't
emphasize
get
closure.
you can't
Yeah.
get the hug on Zoom, but I've gotten a thumbs up emoji. So.
Yeah, not to me hugs as a judge, a mediator every once in a while. So anyway, so Lawrence, when do you think demands should be made? Should it be made before mediation, during opening, after caucus? What do you think?
I prefer they come early. I think that really even when mediation might be set, because it allows for that proper evaluation, obtaining of the authority, the consideration and evaluation of a case. And I think it becomes a real problem when, there's been some casual conversation after a depot and someone says what they're looking for, and then they mention it to the, decision maker, and that becomes sort of the anchor. And then all of a sudden at mediation, this has been escalated to a new figure, and it's a surprise to the person that has the checkbook. And so, I think there's some justification sometimes because some activity took place, but just because a few hearings or a depot or something doesn't mean the demand should, be inflated uh, multiple, and that happens sometimes. So, and I get that sometimes you really can't calculate, or you just haven't had the, meeting with the client that you got to the figure that you're going for, and explain to them that you have to start somewhere else to get to the figure they're going for. So it perhaps start in caucus and use the mediator to try and pin down, where you want to start, and something that's not going to completely be a lead balloon and shut down the process from the beginning. So earlier the better, communicated with the backup necessary to get the, powers that be on the other side of the V to come with the kind of authority that could get the case done. It's just my experience that when we don't have that conversation early or have those numbers floated early, it's a lot harder to get done. And whether you do it in the joint session, we can have that first and then talk, and then uh, bring it, or you can, do it at the outset if you think that you ought to convey that to the people sitting in the joint session. Um, one of the questions I had for you, Jeff, was, should the thing even begin with a joint session? We see our colleagues on the West Coast kind of ditching that whole process, and I feel like in Florida, at least, it's very much part of the process. And even if we have a perfunctory one, I feel like I want to start that way, 99% of the time. But tell me about that.
Well, you're right. It's a surprisingly hotly debated topic, and people feel very strongly about it. My own preference is like yours, that yes, we have opening sessions. Now, it depends on the kind of case. I'm also certified in family law, and typically where you have, very personal disputes or probate cases, it oftentimes does not make sense. But I like them. I do remind the attorneys, just as I said I would repeat this, I do remind the attorneys in my opening comments that mediation is an informal and a non-adversarial process. And so I generally don't have a problem with people getting out of control, but that's the argument against it, is that if you allow the people in the same room who are just going to argue the case, that gets the mediation off to a bad start. So you have to say this is not an adversarial process. It's a carve out of the litigation process, and it's an opportunity for you to talk to the other side in a meaningful way, a constructive way, and it's my job to see that that happens. Um, you know, I can sometimes, when a party is hesitant, I'm not going to talk them into doing an opening session, but sometimes I will say, well, at least how about if I make my opening comments to both sides together to kind of set the table, if you will? I think that's helpful. I like to sort of create, sort of an air of formality to the mediation process. I treat the process with great respect. I like to convey that in an opening session jointly if I can. So sometimes I will say, look, if you don't object to it, let me make comments even if you don't want to. Now, as a practical matter, when I do that, they often, even though they say, well, we didn't really have anything we wanted to say in front of the other side, they end up saying something. Lawyers like to do that, and it's fine. Now, let me though say, I have occasionally had opening sessions which got heated. And I'll tell you when I've learned when it happens. It usually is not when one side goes, usually the plaintiff, of course, and then the defendant. That is okay, even if they're somewhat argumentative in the way they make their presentations. It usually can start to go off the rails when the one side responds to what the other has said. And so my practice is as soon as the second person, or how many parties there are, the last group has responded, I will jump in and make some concluding comments. So I try not to allow that to happen. Now, sometimes somebody will insist in responding, kind of getting this back and forth going. And I'll say, look, if you want to say something, you really feel compelled, that's fine. I'll give them a chance to respond and then we're done. And I very much take control. And, I will share a phrase that I use. I learned this, I think, from Terry White, who's one of our legends at Upchurch Watson White Max. But I say, look, guys or girls, my job is to protect the process. I've got to protect the process. And so when I really take control, that's a phrase that I use. And in some sense, my client is the process. So to bring this back to the question, I do like opening statements. I think you have to be careful with them. I think you have to very much control the process. But getting back to your point about preparation, maybe in person versus Zoom, maybe we don't see quite the preparation. I think when parties are making opening statements, it requires a little bit more preparation, and it allows me to observe the other side. So for all those reasons, I favor opening statements. I certainly don't require them, and when they are given, I really try to monitor what is being said so that we don't let it go south. So. Lawrence, when do you think a mediation should take place? Early or right before trial?
Well, right now is any any good time. Early is sometimes the best because you don't know anything about your case, and people say, "Well, then why am I going to go and give something away that I don't know about?" But you can learn things. It doesn't mean the case has to settle. So, we had a local mediator who was trying to implement case management where you'd have two mediations, an early and a late stage. And perhaps in the type of case that it is, and whether it's a value that is significant, that expense is really not a lot in the long run. And so the earlier that a case gets talked about, you have things such as cost and attorney's fees that are not as big of a factor weighing on the value. So, you can always learn stuff at the mediation, return to the mediation at a later date, like when your discovery's done or you had your experts deposed, or even in like an appellate mediation, you're post-trial, but you can push that briefing schedule, you can toll the deadlines and talk about things before the expense of that appeal and getting the appellate counsel and whatnot. So there's, I think a designer availability and when to do and what to do, because the rule's pretty broad and it is a voluntary process. And yeah, the court might have it in their scheduling, or doesn't mean you have to do it, on the last day before the deadline. It's just when you feel like people are going to sit down and have a conversation about it. And oftentimes Jeff and I are following up on cases that mediated early, and it might take an event or two past that day, but certainly then there's another opportunity for a discussion, and those cases do often resolve. So I don't really believe that it's bad early or bad late. Sometimes people say, oh, we should do this on the courthouse steps. We don't need a mediator because that's how we used to do it before all. Yeah, it can work. And when the parties are facing, jury selection and they're looking at what's going to happen, or they've been through a day or two of trial. But I'll sometimes get a call at that juncture even because they want someone neutral to go through. They want to maintain some kind of confidentiality about the offers, or they want to, have a high-low crafted or something like that. So, at any time, as I said, now is the best time. But what works for your case, and we're happy to jump in. So, Jeff, how long should these things last?
Well, of course, they should be short and they should result in a settlement, right? That's what everybody wants.
And, yeah,
There's no,
small claims courthouse where they got next case, please.
well, let me say this. What nobody wants is a lengthy mediation that doesn't result in a settlement. And I learned that the hard way. When I first started mediating, like a lot of people mediators trying to establish themselves, I was just desperate to settle every case and I just wouldn't let people go. And, it's easy to adopt the adage, well, never, never, never give up. But sometimes you have to, and it's just an art really to know when that time is. I do think, as a practical matter, cases are settled for half days or whole days, and you just need to be aware that if it's a half day and you start in the morning, come lunchtime, people probably got other things to do. And so you have to be very aware of that. Same within the evening, 5, 6 o'clock. You don't want to keep people late. And by the way, you can't keep people. I mean, a controlling factor here is people have to be willing and able to participate. So, you hear about these mediations that go into 3 o'clock in the morning sort of thing. Just be careful of that because you don't want somebody entering into an agreement and then later claiming that they weren't of sound mind when they did it. I remember I when I was a judge, rough analogy, but I had a jury trial and I kept the jurors there till like 2 o'clock in the morning. And Judge Perry was the chief judge. He called me in the next morning. I said, "Hey, you can't do that. We can't have jurors walking to their cars at 2 o'clock in the morning downtown." But
I
uh,
got caught after midnight, I was a juror, and yeah, they had to walk each one of us to the car, and so we
yeah.
didn't get, yeah,
And
so
be aware, even then, not to digress too much, but even the jurors wanted to stay, right?
yeah,
And it
no, you
be the
take it
same with
seriously.
mediators. They don't want to come back the next day. People want to get things done, but sometimes it's not a good idea if it's just too late. Let me though mention something. And I've done this twice this week by coincidence. There is a rule, it's in the mediation rules 1.720 that provides for adjournments. And it provides the mediator may adjourn the mediation conference at any time and may set times for reconvening the adjourned conference, notwithstanding Rule 1.710, which says the mediation should be completed within 45 days. So if you read those two rules together, I've taken the position it really gives the mediator broad discretion just to adjourn mediations. Sometimes we reset them, sometimes we don't have an immediate reset date. And I will file something that just says adjourn. The parties mediated, commenced a mediation and adjourn. And the value of that is oftentimes for various reasons. You just don't feel like, and the parties don't feel like the discussion is over. And then rather than putting the imprimatur of a impasse, I don't use that term, but failed mediation, extend it and don't keep people forever. Or when information is revealed and discovery needs to be done, say, hey, maybe this isn't the day for this. Let's come back another day. So I really think that adjournment is right in the rules. I really think that that is a very valuable tool to facilitating settlements, not that day, but eventually. So let me ask you, why do you think some caucuses take so long?
Well, there's definitely some kind of pacing at work that, um, timing of offers and, um, if money comes too fast, sometimes it might affect how demands are lowered. And, I think there's there's things that used to happen in person, like you said, you would leave a caucus, then you'd be like, going to the kitchen for a coffee or something, and there's a little bit of time in between to sort of, well, digest what just happened, what was the instruction to go to the next, but you might have that sort of lull for a little bit. And that makes it more natural than when you're popping in and out of Zoom rooms without doorbells, by the way. So a lot of times, I'm like, I'm going to be back and I'm going to announce myself, but, try not to be talking about something you don't want me to know. But I think a lot of times there's almost an internal mediation going on between lawyer and client. And I want to be able to help, the counsel in the room manage the expectations where the client is unrealistic or being, not understanding something. And so I think that sometimes you can get wrapped up in that, or like you mentioned earlier, the emotions. Someone's got to give you their whole story, how we got here. And that's really their chance to be heard. And so, people get frustrated in the other room. Where were you in that? But some of those things have to take place. In a multi-party case, I always try to make my way around the horn, check on everybody, even if they've, given me, hey, this is my contribution today, and I don't want to hear another thing about, but I'll check on everybody, because I know that used to get frustrating even in person, in a large case where you're not checking on people. So just be patient. We're actually working and we're doing stuff and we're trying to keep it all straight. And that's
Yeah, and
why sometimes, yeah.
and let me say while we're still talking about time, I think the mediator can create a certain sense of urgency in a good way. For one thing, be on time for the mediation, right? So, if it's set for 1 o'clock, open those rooms, 1 o'clock, people know, okay, you're there, you're on it, you're ready. And also, when you're asked to step out of the room, the parties are talking and they ask for help, they ask for help. I kind of watch that like a hawk. So as soon as somebody asks me to come back in, I'm back in. And I think that that's one thing we as mediators can do to, like, say, I'm doing everything I can to move this process along.
So Jeff, what's the biggest mistake you're seeing parties make in the mediations?
So this is pretty simple. It is the belief that each side comes in with a number, or however many sides. And why do we have to play this game and go back and forth? Why can't we just ask everybody what their number is? What's your final number? Let's find out, and let's just do that. Why do we have to spend several hours at this? And the reason that doesn't work, that literally doesn't work, is that no matter how adamant somebody is, they can say, Jeff, read my lips. I don't know if anyone's ever said that, but the equivalent of that, we're never going below X. Or, Jeff, look me in the eye, we're never going above Y. When they say that, and they could say that early in the mediation, I don't ask for that, but they can tell me that. They're not lying. They're not lying. They mean that. But the problem is when the other side makes a move, the world has changed and they have to reevaluate their position. That's what mediations, that's it. I've just told you the secret of mediation. It's that as sure as you are coming into the mediation of where you want to go, and you won't go above or below, when that offer is made on the other side, it changes the world. You have to reevaluate. It's like my little analogy. I don't know if anyone else I don't know, maybe I got this from somebody or I just thought of it myself, but it's like playing with magnets. You hold them one way. I think with the same poles, they push apart, opposite pole, north and south, they pull together. That's mediation. You just want to keep it going to those magnets are starting to pull together, and then people will make more moves than they ever thought they would. So the biggest mistake is just thinking you can short circuit the process. Now, Lawrence, can just anyone appear at a mediation?
So appearance is a touchy subject. We obviously have, a certificate of authority that's available to kind of alert everybody, and you're supposed to, identify who's coming. But again, I don't police that. So I will take as many as are necessary for someone to self-determine the outcome without like a risk of buyer's remorse later by that decision maker. Now, of course, there have been spats with counsel and things even on the way into it, But sometimes, like you said, you'll see a black box with somebody's there or somebody actually physically in the room with a party. I really encourage everyone to allow those people to participate in a way that if they've lived through the day of the mediation, they're more likely to kind of be in line with what that party is going to decide than, say, an 11th hour call to a business partner or a spouse. Hey, this is what we got. And then it blows up the deal because that person didn't have any skin in the game or listen or understand the moves and the machinations of the process. So, as mediators, I think, we're responsible for obviously maintaining that confidentiality. We put that burden on those people that are allowed to attend, but also we're responsible for alerting parties and participants to the interests of the non-parties and the non-participants and how that could affect other people in a settlement. So just making, the parties aware that their consequences of the decision are sometimes elsewhere and have those parties been thought about. So I really am a pretty liberal on allowing people, but I understand that if someone's there to make trouble or corrupt the process, then of course, we're going to try and not have someone interrupt the negotiation. Jeff, what do you think about brackets? Everybody's got a love-hate relationship. I just did an entire case from start to finish using brackets, and it was a really great shortcut. But tell me, what's your philosophy?
Well, I love them for the same reason that some people hate them. They're ambiguous. Brackets are a good, first of all, let's define a bracket, make sure anybody doesn't know. It's a package deal. It's say, I'll go to X if you go to Y. And then if the other side accepts that, then you're at X, they're at Y. And then the way I do it, it's your move if you propose the bracket, if they accept it. And they are sometimes accepted. So that's a bracket. I love them because there are times when a party, they have to be used at the right time. If you're making steady progress, you probably don't need brackets, but sometimes you're not. The moves are small, you're way far apart, or one side doesn't want to move at all. You might suggest, well, how about a bracket? And that's kind of a way to make a move without actually making a move, and it keeps the process going. And as I've already alluded to, keeping the process going is the secret of mediation. I do like to emphasize, though, that, kind of my mediation, my rule, so to speak, that, if you propose a bracket, please be willing to go to the midpoint or something close to it. Because if you don't, my experience, again, learning the hard way, this webinar is all about what we've learned, is a mediation I did early on where a party proposed a bracket. I don't think the other side accepted it, but they looked at the midpoint and say, oh, they're willing to go to X. Or halfway between X and Y. So the mediation kept going, and then that party wasn't willing to do that, and the other party felt very deceived by that bracket. So I always say, look, don't propose this if you're not willing to go to close to the midpoint, because the other side's going to assume that, right? Now, sometimes they will say, well, I'm not, I want to propose a bracket, but I'm not willing to go to the midpoint. I'll say, look, fine. Just let me share that with them. Let me tell them that you're proposing this bracket, but you're not willing to go to the midpoint. And I actually think, sharing the background of how offers are arrived at can be very helpful. Even if it's not in a bracket context, sharing how you arrived at a number, if it was some discussion with a mediator, let me share that with the other side. I think that gives the other side real insight. So again, my short answer is I do like brackets. They are the mediator's friend. Now, some people believe parties that don't ever offer a bracket if you're not willing to go to the other side's number that you're proposing. I don't know that that's necessarily true unless this party keeps offering a bracket where that same number, the other side's number, if you will, stays the same. So maybe that if you keep seeing the same number and over again, you might draw that conclusion. But I haven't found that to be universally true. And let me also say that you can propose a bracket and then offer it with a fixed number or a hard number as well. So it doesn't have to be one or the other. But again, I like them. They keep the process moving. I find they often result in settlements. And so again, their beauty, ironically, is in their ambiguity. Now, Lawrence, I'm going to ask you a question. I do not know the answer to this. Have you tried asynchronous negotiation by email or text? I have not. So tell me all
So
about that.
Uh, there's a couple ways this works. So it could be that it's in the post mediation, you haven't filed an impasse report, but you think there might be a chance to keep the conversation going. You just ran out of time. You can lose the momentum, lose track of the numbers, the offers, and it can get expensive and annoying because people aren't always available. So it's a way of doing stuff, not all together. And it can go like I had one that was in a patent case. It just went on forever, and the people got annoyed because all those calls and emails added up to a bill that no one wanted to pay. But we did get the case done. So sitting down again, like you were mentioning, adjournments might be a way to do that and move the ball quicker. But it's available. It's also available during the session. You can be texting or do something to shorten a move or get some information while you're in another room. So I just think it's something to put in your toolbox, but I don't rely on getting cases done that way because it is sometimes a drag. Jeff, what do you do with the conclusion of the mediation? How do you document it?
All right. Well, we're about out of time, so I'm glad we got to this question. So, I may be a bit of a stickler on this compared to some other mediators, perhaps, but I follow the rule of civil procedure 1.730, which specifically provides that if the parties do not reach an agreement as to any matter as a result of the mediation, the mediator shall report the lack of an agreement. So first of all, I do file reports. I think not every mediator does, maybe unless the parties raise the issue or insist on it, but I do as a matter of course. And if there is an agreement, the rule provides, this is 1.730B, if a partial or final agreement is reached, it must be reduced to writing and signed by the parties and their counsel. And so I take the position that's what you need to have an enforceable mediated settlement agreement. That's the product I'm delivering. What I don't want you to do is pay me and spend time and money, us reach an agreement and it not be enforceable. So I'm the one drafting. It depends on the complexity of the case, but we'll circulate a settlement agreement. I can do it by email, or I happen to use DocuSign. I say, please stay on Zoom till I get your signatures back. So I take a pretty kind of literal approach to this. I will tell you there's a proposed change in the rules because actually Florida statutes does not require the attorney to sign. And so this has been raised, and there's a proposal to eliminate the attorney signing requirement that's in the rule. And I think also to modify the language, which would acknowledge that for example, there are cases where the insurance representative appears instead of the actual defendant and allow the insurance representative to sign. But anyway, that's what I do. It's a written settlement agreement. It's circulated and it's signed. And let me just add, one time I got a call from a lawyer saying, hey, my client's trying to back out of this agreement. We're going to have to, subpoena you to come to court. And I said, well, all I'm going to say, and I had a copy of the agreement. I said, look, it's signed by you, it's signed by your client. All I'm going to tell the court is this is what you got. And it ended up, I think they worked that out. So, all right. How do you follow up, Lawrence, if a case gets close at mediation?
Really got to lay the groundwork during negotiation, that perhaps this isn't going to be done today, but everybody be of a mind to hold the communication open, that perhaps reconvening depending on the circumstances or looking at coming events and seeing like maybe, the hearing on a summary judgment changes the outlook. See on the docket, is there some other inflection point that can lead to talking again? And that's something I think all of us at this group do. We're persistent. We don't like the mediations that fail, and so we're going to call you.
And what do you think lawyers can do to better manage expectations?
We'll make sure the client doesn't drive past the billboard on the way to mediation. No, seriously, we have to have these discussions of the expectation of the case from the time you sign the client up, and certainly before the mediation day itself, and try to be as instructive about the realities of what someone could get at trial, why mediation is sometimes a different value, and that someone can end up with nothing. And I think those kind of the guardrails that you as counsel need to put on so that we can help you get the case to conclusion. So Jeff, the most important lesson you've learned from conducting the mediations the past decade here at Upchurch.
Well, I have to laugh because of my notes. I have highlighted the mediator is the only one in the other room. Well, that's something I knew when
That's
along.
true.
That's pretty obvious. But it's so important to remember that you're the only one that is seeing both sides of the case, and you just have to learn to trust your judgment and your intuition and your instincts. You've got to be your authentic self, and you have to, give the parties an opportunity to, as you say, Lawrence, to express themselves, to say what they need to say, because my belief is that if people of very different opinions about things can talk through those issues, either directly or through you, and you can keep that conversation going long enough, then most of the time, not always, but most of the time, you can get them to agree, or at least to recognize that their area of disagreement is not so large that it's worth pursuing this litigation. And that's what gets cases settled.
Exactly. Thank you, Jeff. Folks, we put up the slide with the CLE number. If you see that now, it's 2408828N, and that's for Florida Bar Credit 1 hour. We're going to have a webinar December 12th. That'll feature Greg Donahue and April Walker. It'll be called Unlocking Your Client's Best Result at Mediation. So look for your emails about the upcoming programs. And thank you so much for joining us today. We hope that you enjoyed it. Send us any questions and we'll try to get back to you on those.
Yes. Thank you, everybody.